Hello everyone, this is your host Urvashi Chauhan. Welcome to Courts Today by Livelaw, your one-step destination to all legal developments in the country. Let us start. The three new criminal laws, namely Bharatiya Nyaya Sanhita, Bharatiya Nagrik Suraksha Sanhita and Bharatiya Sakshya Adhiniyam have come into force today, replacing the IPC, CrPC and the Indian Evidence Act respectively. Key features of the new acts include application in the digital environment, zero FIR, online police complaints, electronic summons, and strict 45-day trial judgment timelines. Special provisions ensure sensitive handling of crimes against women and children with expedited medical exams. The new laws bring significant changes but have also sparkled concerns over expanded police powers and potential implications for civil liberties. The maximum duration of police custody has been expanded from 15 to 60 to 90 days. This raises concerns about increased risks of police excesses and coerced confessions, potentially undermining fair legal proceedings. The new laws also introduce vaguely worded offences related to terrorism, organized crime, and acts endangering sovereignty. Such broad definitions leave room for arbitrary application and can potentially infringe on fundamental rights like freedom of speech and personal liberty. While the government claims the new laws will modernize and decolonize the legal system, critics argue they largely retain old provisions under new labels. The old laws will remain in effect for pending cases and offences until today, potentially causing confusion as the criminal justice system applies parallel laws. Also, you are aware that the Supreme Court had refused to entertain two PILs filed challenging the new laws. While one petition was rejected on the ground that it was filed before the new laws came into effect, the other one was refused, saying that it was poorly drafted. Do visit livelaw.in to know more. The Supreme Court today adjourned the hearing of a plea alleging, among other things, the involvement of the National Testing Agency officers in manipulating the OMR sheets of the NEET undergraduate exam. As you know, the exam has been under the scanner for various reasons. Several petitions were filed before the Supreme Court and in high courts challenging this medical entrance exam. The petitioner in this particular petition is a topper of these exams and had alleged swapping of OMR sheets. Based on that, he prayed to the court to allow him to appear in the retest of the NEET UG 2024 exam conducted on 23rd June. This retest was conducted for 1,563 students who were awarded grace marks. Questioning the prayer, the bench asked that the examination in which the petitioner wanted to appear was already over on 23rd June. At this, the counsel responded by saying that the relief measure may be granted in case a retest is ordered by the top court. The court had previously adjourned the plea to this week after asking the petitioner to withdraw a similar petition filed before the High Court. Ultimately, the court today adjourned the matter to 2 weeks, saying that it would not observe anything in this petition at this moment. Also, in another development pertaining to the NEET undergraduate 2024 controversy, a writ petition has been filed stating that cancellation of this examination will be an arbitrary decision and will violate the fundamental rights of the candidates who appeared in the examination this year. That it will have serious repercussions on the candidates who have worked hard for the exam. Further, that such cancellation will severely cause prejudice to deserving candidates while benefiting only few. The petition has been jointly filed by 5 candidates who have suggested a re-evaluation instead of conducting a re-NEET exam. It has been submitted that re-evaluation can address issues such as rank inflation and a substantial increase in the number of toppers. The Supreme Court will consider the cases related to this exam on 8th July. Stay tuned. In another update, a Delhi court has today sentenced Narmada Bachao Andolan leader and activist Medha Patkar to 5 months simple imprisonment in the criminal defamation case lodged against her by Vinay Kumar Saxena in the year 2001. V.K. Saxena is presently Delhi's Lieutenant Governor. He had filed the case against Patkar in the year 2001. He was then the chief of Ahmedabad-based NGO named National Council for Civil Liberties. Saxena filed the defamation case against Patkar regarding a press note dated 25th November the year 2000. In this press note titled "True Face of Patriot," Patkar accused Saxena of being a hypocrite about his stance on Hawala transactions. She claimed that Saxena visited Malegaon, praised the Narmada Bachao Andolan and gave a check of 40,000 rupees. However, when Lok Samiti attempted to cash the check, it bounced because the bank reported that the account did not exist. Patkar used this incident to question Saxena's integrity and accused him of dishonesty. She had said that Saxena was a coward and not a patriot. Patkar was convicted by the court on 25th May for the offence of criminal defamation under IPC. While convicting her, the court had said that Patkar's actions were deliberate and malicious, aimed at tarnishing Saxena's good name and have caused substantial harm to his standing and credit. It also stated that she could not provide any evidence to disprove these claims or show that she did not intend or foresee the harm her statements would cause. A bench of Justice Ranjan Roy and Justice Om Prakash Shukla of the Allahabad High Court today heard the PIL plea filed by Karnataka BJP worker S. Vignesh Shishir to set aside Congress leader Rahul Gandhi's election as an MP from the Rai Bareli Lok Sabha seat on the ground that he is not an Indian citizen but a British citizen and therefore ineligible to contest the Lok Sabha polls. During the hearing, Advocate Pandey for the petitioner argued that Rahul Gandhi is a British citizen, making him ineligible to be an MP despite his conviction being stayed. He claimed Gandhi lost Indian citizenship by acquiring British citizenship and highlighted a 2019 notice from the Union Home Ministry seeking clarification on Gandhi's citizenship, to which Gandhi had not responded. The Election Commission's counsel refuted this, stating that the issue should be addressed in an election petition. It was pointed out that the Supreme Court had already dismissed a similar plea. When asked about his sources, Advocate Pandey admitted to downloading the documents from the internet. The bench then advised him to approach the concerned authorities who have the power to determine someone's citizenship, stating that the court's hands were tied in this matter and could not do much while hearing a PIL plea. But the hearing in this matter today took an unexpected twist. The bench had to rise after it took exception to Advocate Pandey's incessant arguments. Significantly, during the hearing, which lasted about 90 minutes, the court repeatedly asked the advocate to conclude his arguments, noting that he had already been heard for a substantial amount of time. As he continued, the court rebuked him, emphasizing that he should maintain the court's decorum. The court also asked him first to answer its query regarding whether there is any judgment from the Supreme Court which states that the disqualification of an MP or MLA remains even after a conviction has been stayed. Thereafter, when Advocate Pandey kept arguing, the bench decided to rise. To read the entire courtroom exchange, you can visit livelaw.in. And now let me tell you, Delhi Chief Minister Arvind Kejriwal has moved the Delhi High Court challenging his arrest as well as CBI remand in the corruption case related to the alleged liquor policy scam. Kejriwal is presently in judicial custody in the corruption and money laundering cases related to this alleged scam. Last week, the probe agency had examined the Chief Minister in Tihar jail, where he is lodged in judicial custody in relation to the money laundering case being probed by the Enforcement Directorate. After court's permission, CBI examined Kejriwal in court on 26th June and then formally arrested him in the matter. The Chief Minister was remanded to CBI custody for 3 days on the same day by vacation judge Amitabh Rawat, observing that the arrest at this stage would not be said to be illegal. Now the Chief Minister has approached the High Court in this regard. Stay tuned to know more. The Delhi High Court today asked All India Trinamool Congress MP Saket Gokhale to pay 50 lakhs damages to former Indian Assistant Secretary General to the United Nations Lakshmi Puri in her defamation suit against him. To give you a short background, Gokhale in his tweets had referred to a property purchased by Puri in Switzerland and raised questions regarding her and her husband, Union Minister Hardeep Puri's assets. He had also tagged Finance Minister Nirmala Sitharaman in the tweets and sought an ED inquiry. The suit contended that Gokhale's tweets were false and defamatory, and that the tweets were maliciously motivated and designed to deliberately twist the facts. In July 2021, a coordinate bench had ruled in favor of Puri while deciding the interim injunction application in the suit. The court had then directed Gokhale to take down the tweets in question within 24 hours. He was also restrained from posting any further defamatory material against Puri. Now, Justice Anup Jairam Bambani of the Delhi High Court, while decreeing the suit, has asked Gokhale to put an apology in Times of India. He has also been directed to put the apology on his Twitter handle, which has to stay for 6 months. West Bengal Governor C.V. Anand Bose has approached the Calcutta High Court in a suit of defamation against Chief Minister Mamata Banerjee. This is because the Chief Minister allegedly made comments against the governor, stating that she had been informed by women that they did not feel safe visiting the Raj Bhavan due to recent allegations of sexual harassment against the governor by a former Raj Bhavan employee. In response, the governor reportedly stated that those holding high offices, such as the Chief Minister, should refrain from making erroneous and slanderous comments. He had subsequently stated that he would approach the Calcutta High Court against the Chief Minister for making comments which had defamed him. And lastly, the Rajasthan High Court has reiterated that Lok Adalats do not have adjudicatory powers, and hence the order of a Lok Adalat allowing withdrawal of a criminal prosecution cannot be sustained. The bench of Justice Anil Kumar Upman was hearing a petition seeking quashing of an order of the National Lok Adalat that allowed the Assistant Public Prosecutor to withdraw the criminal prosecution in a criminal case and acquitted the accused. It was argued by the petitioner that the order was illegal, arbitrary and contrary to law, since Lok Adalat does not have the jurisdiction to allow such withdrawal. A Lok Adalat could dispose of cases only on compromise between parties. It was further contended that the decision was in gross violation of principles of natural justice because no notice was provided to the petitioner before passing the order. The court quashed the order of the Lok Adalat and accordingly allowed the petition. The criminal matter was directed to be restored before the competent court. If you wish to know more details about the cases that I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Livelaw. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos, or consider becoming a member at just 89 rupees per month.